Welcome back to this Sunday, January 29th, 2012 edition of the Teri O'Brien Show, and as promised and long anticipated, a return appearance by Van Irion of the Liberty Legal Foundation. And you guys know in this audience, I know you've been following this case, the case in Georgia on Barack Obama's eligibility to be on the ballot. And as I said earlier, and I said back in November when Van was kind enough to visit with us before, this case that he is pursuing is one near and dear to my heart because I'm not exactly a birther. I am an Article 2er. And Van and the Liberty Legal Foundation is pursuing the case that Barack Obama is not an Article 2 natural-born citizen because his parents were not citizens at the time of his birth. Welcome to the program, Van Irion. Hi. I want to have you, for people who may not know and who are just learning about this case from the Teri O'Brien Show, I want you to describe the case, your plaintiff, Mr. Weldon, and the relief that you are seeking. Why did you file a case in November, and what relief are you seeking? And then we'll talk about what happened just this past week.
Well, you made the most important point, and that is this is not a birther case. This has absolutely nothing to do with where he was born or, whether or not he's a U.S. citizen. We actually stipulate that he was born in Hawaii and that he's a U.S. citizen. Now, I don't know if that's true, don't really care, because the point is, under Article 2, as you said, every person running for president or serving as president has to be a natural-born citizen. And that term was defined by the Supreme Court in 1874, as a person born in the United States of parents that were both citizens.
Correct. Yes, and that's the basis for your case that you filed in November, correct?
Exactly. And because Obama has admitted on several occasions that his father was never a U.S. citizen, he's not a natural-born citizen.
And this is why, and I first made contact, when I first invited you on the show last fall, I sent you a column that I had written for Illinois Review talking about this issue. And we understand why they make such a fierce effort to conflate the issue of the location of his birth with the issue of Article 2. Because, of course, Van, if you're correct, which I believe you are, game over.
Right. And they have so marginalized the birther movement that, they want to put us together with that, and they want to confuse people, and they're desperate to not have this very simple issue addressed.
But they don't use Saul Alinsky tactics, as we heard from Chris Matthews earlier in the program. They would never do something like that. Now, last Thursday, there was a hearing. Now, this hearing took place because earlier this month, a Georgia administrative judge refused to quash a subpoena at the request of the Obama folks, granting them the right not to appear and produce documents showing he's eligible to be on the Georgia ballot. And last Thursday there was a hearing, and he was supposed to appear either through counsel or himself, and come to find out, nobody showed up. Right?
Yeah, and let's be clear. He was ordered to be there and counsel. It was not. Just counsel showing up wouldn't have been good enough. But now we're getting to what, in my opinion, is way an order of magnitude more important than anything we're arguing about at the hearing. We now have a president that has openly, publicly stated that he is beyond the reach of the third branch of government, and to my mind, that is internationally important, historic, something that nothing even comes close to it since Watergate, and this is beyond what Nixon did. At least Nixon, when he was fighting subpoenas, he acknowledged the authority of the court, sent his attorneys to court when they were supposed to be there, and made the arguments that were supposed to be made. This president has basically said, I don't care what the courts do. You can't do it. You can't touch me. And that means that we don't have a republic anymore.
Oh, you're absolutely right. I posted at my blog today a list of, and it's it's not by any means a comprehensive list, of the many acts of lawlessness of this administration. And it's ridiculous. I could write a book about it. I'm sure you could. Maybe we ought to collaborate on that book. But This bunch has said that they decide that the Defense of Marriage Act is unconstitutional, and they're just I'm not going to enforce that. Even though I took an oath to faithfully execute the laws, never mind. That's when I don't want to enforce that one. And
right.
now, and the real irony is, wouldn't it be ironic if this lawlessness were stopped because the guy is not eligible, so his very presence in the office is lawless?
Well, that'd be great, wouldn't it? I mean, what we need from this court is a strong order of contempt, and it needs to result in some sort of punishment that's commensurate with the crime. I mean, if anybody else just didn't show up in court, they'd be held in contempt of court.
Oh, you're absolutely right. And some of the chatters are kind of having a little fun with this, and they say maybe we could get him down there by telling him there's a golf course near there. But I don't think that's going to work. Now, it's Thursday. We actually had our own special correspondent there, and he's going to be talking in a moment. But there were 3 cases, actually. There's your case, and then there's the Orly Tate's case, and the case with the state representative. I think his name is Mr. Mark Hatfield. And the other 2 cases do focus on the issue of the location of his birth. So there's 3 cases, and yours is really the only one I think like I said, is near and dear to my heart. Can the judge rule on your case favorably or unfavorably and rule in a different way in the other 2 cases? Would that be feasible?
Absolutely, and in fact, he had consolidated the cases back in December. We filed a motion to separate, specifically pointing out the differences between not only the legal theories but the facts that we were asserting, and based on that, separated the cases again. And therefore, I mean, he can, and actually probably should file different opinions and different conclusions in all 3 cases.
Oh, that's excellent. And he's scheduled to rule. I'm getting conflicting information. I am told he wants everything finished by February 4th. Is that your understanding?
No, it was February 5th. However, he changed it the next day on Friday. He sent out an order saying, hey, we want the proposed orders by the 1st. And in fact, I was working on mine when the time for this call came.
Oh, my producer was like, "Oh yeah, he's just sitting in his office working." It's like, of course he is. He's always working. You got to work 24/7 when you're fighting this bunch. I'm telling you, because they're working 24/7. So we got to be working 24/7. So that'll be interesting. So that's Wednesday then.
Yeah, and the order actually indicated that the court would be ruling immediately thereafter. So I expect a ruling probably on Thursday.
So will this be, I mean, let's assume that since he did not appear, will this be some sort of a default judgment against him if the judge rules against him?
Well, in fact, the judge wanted to enter a default judgment on last Thursday. However, all 4 attorneys involved argued vigorously against that, and here's why. The Obama administration wants desperately to avoid having any court rule that he's not a natural-born citizen. And this court, I mean, even though this is just an administrative law court in the little state of Georgia, having that court rule that he is not a natural-born citizen as defined by the United States Supreme Court construing the Constitution would legitimize everybody, and it would also clarify the fact that this is a completely different argument, has nothing to do with where he's born. The legitimacy that would come from any court ruling it would absolutely devastate the Obama administration and would lead to further court rulings against him. That's what they want to avoid, and so their method of avoiding it was to just simply not show up and hope that at worst a default judgment would be entered, and that way you don't have a ruling on the merits.
Yeah, okay, yes, of course. So that's why, and what everyone's saying, like, why do you think he failed to appear? Yes, this is what I think as well. I'm thinking he didn't want to appear because then the actual merits could be adjudicated. And with respect to the cases revolving around the legitimacy of the birth certificate and all of that, if those folks are right, and then if he presents more phony evidence, then he's got a Clinton perjury problem. He doesn't want that.
Right. Basically, it boils down to, it's very simple. He knew if he showed up, he'd lose. And if he lost on the merits, that's really bad.
Very bad. Well, there's an old saying in boxing, you can run but you can't hide. I mean, does he think if he just pretends it's not there, everyone's going to go away? We're not going away.
Well, yeah, he's just going to he's going to make us work for it. He's going to make us, just pray that this judge actually does rule on the merits and doesn't just enter a one-sentence default judgment.
It takes courage. It takes courage for a judge in this situation to rule on the merits. I think you probably would agree.
Oh, absolutely. Yeah, this judge has shown unbelievable backbone in not quashing the motion or the subpoena to have Obama appear.
Now, how do you respond to those who say, and I don't claim to be one of them, but I have to ask you the question, those who say that the genuine terror that this litigation is causing is because it's a gift to the Obama campaign, that it will allow the Obama campaign to go full Alinsky on all of us, conflating the birtherism and using demagoguery to get people to overlook that this is a purely legal, constitutional issue. It's very difficult in our soundbite, low information, celebrity culture to make a reasoned legal argument, to even present it before the public. And they have such an advantage of being able to use the Saul Alinsky ridicule on us. So how do you respond to people who say, this whole thing that you're pursuing is a gift to the Obama campaign and you guys should just stop?
My response is I am about defending the Constitution because that is the only thing that created the country that we have now, and if it goes away, then all of our prosperity and security go away. And it really is beyond, much more important than the specific circumstances of any given case. That's what constitutional law, that's why we've lost our Constitution, is because even the judges that are deciding constitutional law have been swayed by the specific circumstances of a given case, and that's where you get bad law from, rather than just remembering that principle cannot change based on circumstances or it loses its identity as a principle.
Yeah, that's what the rule of law is all about. It's all about, justice, the blind justice. It's not, as Aristotle said, the law is reason free from passion. And that's what we need to remember. On your site today, and if you're just joining us on the Teri O'Brien Show, we're talking to Van Irion, the founder of the Liberty Legal Foundation. And you go to libertylegalfoundation.org, and we'll put the link in the show notes. If you go there, you can maybe throw a few bucks in the tip jar for him to help him keep going with the litigation. And also, though, read about, you've got so many great things on your site about Obamacare. You've got not just this litigation, so definitely, kids, check it out. But today you've got a great piece about something that I go round and around with people about, and that's Marco Rubio. You're talking about what about Mitt and Marco. I go round and around with people about Marco Rubio because he is like the darling of many conservatives for good reason. He gave the response to Obama yesterday, the Saturday address, and he did a brilliant job. But in fact, he might have the same problem. He may not be an Article II natural-born citizen, correct?
Yeah, absolutely. And this is a perfect example of what we were just saying. Principles don't bow to circumstances. He might be a great guy. He certainly seems like he'd be a great vice president, possibly a great president, if it wasn't for the fact that he's not a natural-born citizen. And I would fight him just as much as I'm fighting Obama, because what's important here is holding to constitutional principles. My understanding is his parents didn't naturalize until he was 14 years old. Well, the rule from Happersett from the Supreme Court is 2 elements. You got to be born in the United States, and at that time, both of your parents have to be citizens. Now, that doesn't mean that they were necessarily born here, but they could have naturalized. So if his parents had naturalized before he was born, he'd be a natural-born citizen. But since they didn't, he's not.
Yeah, and I guess it's interesting because a lot of folks maybe that's part of why a lot of folks on our side are not commenting on this one way or the other. They're sort of kind of got a little bit of a cold feet problem going on when it comes to addressing this legal issue. They don't say one way or the other, but they don't want to talk about it. Perhaps that's why they believe it's in the interest of their political fortunes to, ignore this Article II thing. Maybe Marco Rubio can ignore it the same way Barack Obama did. That'd be just fine.
I have a different theory, and I actually got this from a staffer that works for a senator here in Tennessee. He said, and it makes perfect sense, he said that if you attack Obama on this issue, if you have any kind of success whatsoever, it's going to enliven his base for the election. Therefore, Congress is not going to do anything. No one on the Republican side is going to raise issues that might make the base that supports Obama mad and get them out during the election.
Oh, I think that makes sense. Yeah, absolutely. Yeah, absolutely does make sense. And that goes back to the whole argument about this litigation being a gift to the campaign, But I agree with you. I think we can't, at some point, principle and the rule of law has to be defended, or else, we're done. I mean, what are we here for? Now, what do you think on a related issue, legal issue, not relating to the Georgia ballot initiative or the ballot eligibility case, but the Obamacare litigation that's coming up before the Supreme Court? They're going to have a couple of days of arguments, I think, in March. And I think Elena Kagan is so far indicating that she does not intend to recuse herself. What do you make of that?
Isn't that great? We've got, that's just wonderful. The liberals were arguing that Justice Thomas should recuse himself because his wife actually has an organization that fought against Obamacare, but, Justice Thomas wasn't directly involved in it at all, but that was good enough for the liberals to argue that he should recuse himself. But now we've got someone who actually worked for Obama during the time that they were trying to get this legislation through, and yet she's not going to recuse herself, and no one on the liberal side is saying anything about it. Isn't that just great?
It's unbelievable. It's amazing. Now, what's really interesting is my producer is saying, if Obama were a Republican president, you, Van Irion, would be on every network every night talking about this case and talking about Elena Kagan not recusing. Don't you think?
Oh, yeah, absolutely. And, in fact, I know quite a few people. I've been on Fox News a few times, and I know some people down there, and they will return my phone calls and my emails and my texts about just about any subject. They call me sometimes. But when it comes to anything having to do with this particular case, they will not even return my calls.
Isn't that interesting?
Yep.
That is really, it's truly amazing. Now, speaking of friends and returning your calls, my show is rebroadcast on Red State Talk Radio, and the founder of that network, Primo Mondoni, is a friend of yours, and he said you were going to be coming on the show, so be sure to give a heads up to my old friend Van that he was talking about how you ran for Congress and all these things, so... it's a small world. We all kind of know each other, but I like to hang out with smart guys, so I'm glad that you guys know each other. Yeah.
And I didn't know you knew him. That's great.
Oh, yeah.
He was, if I recall, he was pretty active in the fair tax movement.
That's right. And this show is the Red State Talk Radio Talk Show of the Year for last year. And I'm sure that's largely due to great guests like you, Van. So, because you were on in November. Okay, so what's the end game? I mean, what is the end game? We're watching for Wednesday. Will the judge give his opinion on Wednesday? Will he write an opinion and publish it later? When are we going to know that the case has been resolved one way or the other?
He has always just issued a written opinion on everything that he's ruled on. I expect that probably Thursday or Friday at the latest. But you have to understand, after this court issues its opinion, the final decision is still up to the Secretary of State of the state of Georgia. He has a certain period of time, I'm not sure what it is, to make that decision. I'm sure he'll make it quicker than his time limit because the primary is coming up. But after that, of course, Obama's going to appeal and try to get the appellate court, the next court up, which is the trial level court in the state of Georgia, to suspend the judgment, and then he'll just delay throughout the rest of the election. So, we'll fight that. We'll fight whatever happens. We'll keep fighting. But at the end of the day, this is much less about whether or not Obama's name appears on the Georgia ballot than it is about getting this court to actually rule on the merits and determine that he's not constitutionally qualified.
Oh man, that would be something. And my hat is off to you. You are a hero, and I'm just delighted that you came on the show today to class up the show and to enlighten and inform all of us about this. And I hope that Van Irion of the Liberty Legal Foundation you'll come back. And guys, go to libertylegalfoundation.org. I posted the link in the chat room. I will post the link then in the show notes for this program. And, Godspeed.
Thank you so much, Teri. I really appreciate it.
Come back again?
Yep, absolutely.
Okay, good luck. We'll be thinking of you on Wednesday.
Thanks a lot.
Thanks. Ben Irion of the Liberty Legal Foundation. What a great guy. Okay, quick break, and then more about the Georgia ballot eligibility case from the criticulator, who was our special correspondent. He was actually there in the courtroom when the case went before the judge. So stay with us.
Yeah, Terry, I was there, and I can say at long last, those of us who've been laboring in the unrequited, much maligned, and often defamed vineyards of the issue, questioning Barack Hussein Obama's eligibility under Article 2, Section 1, Clause 5 of the U.S. Constitution have now been partially vindicated. Barack Obama has legally stipulated to the following issues. First of all, that he is not a natural-born citizen constitutionally qualified to be President of the United States. That he has 27 Social Security numbers associated with his name and at addresses at which he is known to have lived. That the Social Security number that he's presently using was issued to a man born in 1890 who died in Hawaii in 1981 that was issued from the state of Connecticut, a state wherein he has never resided. That an E-Verified check of his Social Security number reveals that it is most likely fraudulent. Experts testified that the certificate of live birth that Obama submitted on the White House's website shows evidence of having been digitally manipulated and having lines of text copied and pasted onto it from legitimate birth certificates of the time period. That his father, Barack Hussein Obama Sr., was never a legal resident of the United States, much less a citizen of them. That the 1874 Supreme Court decision of minor versus Happenstance defining a natural-born citizen as having two citizen parents is correct. That the 14th Amendment does not alter the original definition of natural-born citizen in Article 2, Section 1, Clause 5. That the Democratic Party may have nominated Barack Obama as its candidate for the President of the United States, knowing that he was not constitutionally eligible, and conspired to mislead the American electorate that he was so qualified. That records exist to show that Barack Obama was residing in both the state of Hawaii and Indonesia at the same time, and that this is an indication of an attempt to hide his true identity and citizenship. Now, the reason that President Obama can be said to have legally stipulated to all the foregoing is that he had been duly served with a subpoena from Judge Michael Mahili, the Office of State Administrative Hearing Court, ordering him to answer the charges of plaintiffs in 3 separate cases involving his eligibility to appear on ballots in the state of Georgia as a candidate for the Democratic presidential primary for President of the United States. The court received a response from Obama's attorney, Michael Jablonski, wherein he said that both he and his client were, quote, suspending their participation, unquote, in the hearing. They, in fact, did not appear or offer defense to any of the charges. This is akin to one team being on the football field all suited up and ready to go, and the other side failed to show. Accordingly, the judge was inclined to enter default for the plaintiffs right then and there, but the plaintiffs prevailed upon him to allow their testimony to be entered into the court record so as to ensure a factual and evidentiary basis for any subsequent appeal by the defendant, Mr. Barack Hussein Obama, who, by the way, was subpoenaed as Mr. Obama, candidate for the presidency of the United States on the Democratic ticket, not President Barack Obama. And all of this remains unchallenged, all of it. The question of Obama's eligibility to serve becomes official. No longer the stuff of speculation, no longer dismissible by Obama, and this is something which will never be heard in court. Obama's eligibility is now a matter of an official court record. One of these cases argued that it didn't matter where Obama was born, but what the nationality of Obama's father was. You just heard Attorney Irion speaking to that. Obama's father was never a U.S. citizen, and a great deal of evidence to that point was entered in the official record. And the opinion, which is backed up by several Supreme Court opinions, that for one to be a natural-born citizen, both of one's parents must be U.S. citizens. For those who think otherwise, the question must be asked, why did the framers of the Constitution change the language from Hamilton's proposed born a citizen to John Jay's suggested natural-born citizen? And that term was first codified in colonial reference books in 1758 in the legal reference book Law of Nations. That legal reference book was used by John Jay, who went on to become the first Chief Justice of the Supreme Court. Jay had the clause inserted in the Constitution via a letter he wrote to George Washington, the leader of the Constitutional Convention. Jay was considered the outstanding legal scholar of his time. He was the one responsible for inserting that term into the U.S. Constitution, which was derived from the Law of Nations. John Jay wrote, Permit me to hint whether it be wise and reasonable to provide a strong check to the admission of foreigners into the administration of our national government, and to declare expressly that the Commander-in-Chief of the American Army shall not be given to, nor devolve on any but a natural-born citizen. There's no opinion offered at any time by the Supreme Court in conflict with the decision definition, and no lower court opinion saying anything else overrides or conflicts with the Supreme Court decision from 1875 in Minor versus Happersett, which Attorney Irion referred to. Now, that definition of hell, Obama is not a natural-born citizen, has no standing to hold the office of president as per the Constitution. Why no media coverage? You just speculated on that, Terry. But I suspect there's a great deal to do with the prior position that the birth certificate was real. Case closed. I suspect that should the judge find compelling reason to exclude Obama from the state's 2012 ballot, this will become a story. How often is the sitting president subpoenaed? How often is the sitting president's eligibility to appear on a state ballot been questioned in court? How often is the sitting president's birth certificate been questioned as fake under oath? How often is the sitting president's eligibility to hold office been testified to in court? How often is the sitting president's nationality been testified to in court? This is news regardless of what side you take. Never before has the sitting president's Social Security number been shown by evidence and sworn testimony in court as being fraudulent. Now, at the end of the hearing, Judge Michael Mealy adjourned the hearing, gathered up all the evidence, and the court reporter's transcript returned to his chambers. Now, we don't know for how long we'll have to wait for his decision of whether or not his name is eligible. I think we just heard February 1st as when he will render his decision. But one can easily suspect that should he find against Obama in this hearing, a tidal wave of similar cases will be filed in other cases. Already similar cases are pending in some states. Should that be so, Barack Hussein Obama and the Obamianists will not be able to find enough little Dutch boys to stick their fingers in the dike. We can also wait a decision of what any action might be taken regarding Obama's failure to appear in his attorney's decision to simply not participate under a court subpoena. You know, Obama exemplifies the exact reasons why we don't allow foreign-born nationals to have the keys to our kingdom. He blames this nation for everything. He hates it. He makes decisions that are detrimental to it. He codes up to our enemies. He grants rights to other nations he denies his own. He's the enemy of the armed forces, the willing friend of our enemies, and the closest thing we've had to Manchurian candidate in our nation's history. I wonder if all this will hurt sales of his birth certificate coffee mugs. And with that, let me just say, Barack Hussein Obama, not much longer, not much longer, not much longer. You're going to be gone.
Oh, what an awesome criticulation. Actually dispensing with your music, your conclusion music, because we're out of time. We went a little long with the guest, but it was well worth it. I'm going to